Pete, I have in my hand here a banned item in the state of Washington.
Yeah, it's an accessory to a firearm, according to our Supreme Court.
It is. So this is
Not an integral part.
Right, not integral. This is a 30-round capacity magazine. This is the standard capacity magazine that was furnished with the weapon, but it's illegal as well now. It's 15, even though it was standard capacity when this gun was manufactured. And that's what we're talking about today. Why are we talking about that?
Because it's 2A Tuesday.
I like 2A Tuesday.
And we're talking about going all the way, baby. Scoring the touchdown at the United States Supreme Court. And that's what we plan on doing.
That's crazy.
Yeah, I mean, it's funny. When we kicked around the idea of the foundation, we talked about fighting for our rights. And, one day we'll go to the Supreme Court. And it was like, this starry-eyed gaze kind of notion that we'd bring issues that were important enough that the U.S. Supreme Court would want to hear them. And I believe that the Gators gun case is that issue. Not the sole issue that we work on, but the first, I believe, of several. For folks following along, obviously, let's just start with what we're doing here. We're educating you, but it's a hard pitch. This is not going to be cheap. Everything we do has to be done to Supreme Court level perfection. So, if grandma's coming over, you're cleaning the corners, you're actually getting the crap out of your bedroom, you're dusting the shelves that haven't seen the light of day for however many years. It's all that stuff so you don't get your butt beat. Right. And that's where we are. This has to be teed up to perfection. I mean, just the hard costs alone, I don't have it offhand. But think about this. We are going to have to contract someone to print this because we could get kicked out just for printing or putting the wrong color of a cover sheet on. There's like a pink sheet, a blue sheet, and a yellow sheet, and that designates the parties and the type of brief. So, those are things that we don't even want to trifle with. And for everything we produce, 40 copies. So, and these briefs, if you've ever read them, and I'm sure our followers have read some of them, they're not just like 3 pages. You're printing 100 pages. You're printing dozens of pages or hundreds of pages 40 times over, and the cost is it's going to soar. So we are talking about it because we're excited. We think that we've got a viable case that we're going to petition, and we can talk about that, and we can talk about why the Supreme Court would want to hear this case. But the only way we do it is the support. And while we appreciate the attaboys, the prayers, and we need all those, we absolutely and desperately need to fund this case. Otherwise, we'll get to the goal line and we'll Marshawn Lynch it, or I guess throw Russell Wilson.
I get Russell Wilson.
That's fair. It's not Lynch's fault. He didn't get the touch.
Marshawn would have put it in. So it's still a little bitter about that. I know you're a 49ers fan, but we don't hold that against you. I mean, I guess I kind of
not here.
Beyond the cost of printing the paper, beyond the cost of just the boring legal stuff. We've had expenses in this case they're just astronomical. This is not a cheap endeavor, and that's why you're constantly seeing the likes of the NRA and Second Amendment Foundation and those other specific 2A groups that are constantly fundraising, and that's the situation we found ourselves in. We know now why they are constantly fundraising, because this costs so much. This takes so much resources and money to just keep this thing going.
Yeah, I think our expert witnesses alone were like $30,000 or $50,000 at the trial court, and then again, that was a trial court. Then we had the emergency motion for stay. Then we had the state Supreme Court and everything in between that we had to do. Don't forget, we have whether or not the ban on the magazines is constitutional the case has been bifurcated or split in half. The constitutionality of the law is what we're going to petition to SCOTUS, the U.S. Supreme Court, in August. Mm-hmm. There's still a question of whether or not Wally and Gators are on the hook for fines for allegedly selling these magazines in violation of the law. We're still kind of batting that around to figure out, how that proceeds. It would proceed. I mean, I can tell you how it proceeds in the sense that it goes back to Kelso and we'd be back in front of Judge Basher. But, the when, the where, and whether or not Judge Basher issues a stay. I mean, we may be litigating these two things simultaneously. And if somehow SCOTUS gets ahead of Basher's ruling, midstream, we could have we're priming for final trial on the Consumer Protection Act, but SCOTUS says it was illegal. So now it all goes back. I mean, so there's a lot of work that has to be done to make sure that, our clients' interests are protected while simultaneously protecting the rights of you and I.
Well, let's kind of list those out a little bit. First of all, we're challenging whether this law is constitutional, right? The magazine ban. That's the first thing that we're fighting.
That's what has been in the bullseye this entire time. So it started off with the state, throwing its punch.
Right.
You violated the Consumer Protection Act. We're going to hammer you. We think you've sold this number of magazines, and penalties can reach in this number, and it's tens of millions. Now, when we went to try, or we had a hearing on that, and Judge Basher, we basically said, we want you to, what I said earlier, bifurcate the case. We want you to address the constitutionality of the magazine ban, and then later address whether or not there's a penalty if you deem it constitutional. We all know what happened there. First, he rules in our favor, splits the case. Basically stays, and we've heard that word, and it's often been used as a bad word because of our 88 minutes of glory.
Right.
He stayed the Consumer Protection Act question, just said, okay, I got to decide whether or not this is a constitutional law. And if it is, cool, we can address penalties. If it's not, we're not even talking about penalties, because I'm not going to issue a penalty from my bench. And I'm putting words in his mouth. I'm not going to issue a penalty from my bench under an unconstitutional law. And so for the past, year and a half that we've been going, everything from Basher's Court to Commissioner Johnston to Washington State Supreme Court, we argued in January, and 2 weeks, 15 days ago, I think now, May 8th, so 12 days ago, we get the opinion from the Washington State Supreme Court. And as everyone knows, 7-2 decision, 7 in favor that this is a constitutional law, that not a problem prohibiting the sales, importation, manufacturing, or distribution of so-called large capacity magazines. Now it starts a clock for us to tick, 2 clocks that we're playing with. The first one that we've focused on, and I think it's important that we stay focused on this, is taking this case to the United States Supreme Court. Everyone that's followed Second Amendment issues, and I haven't seen anything change today, there are other magazine ban cases out of courts of appeal, United States courts of appeal, the federal courts of appeal, that are still sitting in conference that have been kicked around for, I think, like 9 or 12 conferences. I'd have to look exactly, but there are 2 cases, and they've been talked about a lot in the 2A forums. And I've been a firm believer that SCOTUS knows that there's a Supreme Court somewhere out there that's going to rule exactly like the Washington State Supreme Court has, which is to say that these bans are lawful. Mm-hmm. And I think it's a much sexier approach. And I know people don't think of the justices and say sexy. That's not necessarily synonymous. But
definitely not.
I think this is a more attractive hook for them.
Yeah.
Because you have a court of final opinion that's, you're still like the referee over them, but they're almost your peers, right? The appellate courts are, mid-level managers. You're the executives, right? When you're talking from the eye of the beholder of the Supreme Court. But here you have 50 state Supreme Courts that make laws for the states. And you don't always get a way in on that.
Right.
But through Heller and McDonald and Bruin, cases after Bruin, cases in between, primarily those 3, though, the Supreme Court has put this roadmap of when you address a Second Amendment issue, here is how you do it. You do not interest balance.
Right.
Expressly said that.
And that's so. First of all, I want to add 2 points. One, is this going to be called Gator? What's this case going to be called? Gators versus
Well, presently it's Washington versus Gators guns.
right. So when it gets to the Supreme Court, what's it going to be called? Because we got Heller and Bruin. I mean, those are decent names, but I mean, if we've got Gators,
I mean, I think it's gonna be Gators.
if it's going to be Gators, I'm
Gators.
excited.
I think it's gonna be Gators custom guns.
And it's just going to be Gator, and everyone will reference Gators. If we go to the Supreme Court and we win, everyone's going to be referencing Gators from here on out. And I want to make a point of that because Wally at Gators just, I mean, to stand up the way he did, he's put himself in the crosshairs, and I can't tell you how many Second Amendment enthusiasts claim that they would do the same thing, but I'm going to tell you right now, looking at from Wally's perspective, I guarantee most of them would not put themselves in the situation he's put himself in because he believes in his right and is standing up for it. So I want to really hammer that home to those of you that are following along with this that claim to be Second Amendment supporters. Put your money where your mouth is. You know, Wally really has in this situation, and guess what? His Gators is going to be etched into history because of his willingness to do that. Not just because he's a veteran and all the other things that he's sacrificed in his life for his country and his beliefs and his principles, but because he's been willing to stand up and put his life on the line and that legacy as well. And I had a second point, but I can't remember what it was now because I went so far into this. You were talking about what was the next thing?
About the case, and we were talking about the magazine ban and Heller and Bruin.
Oh man, I had a second point.
Interest balancing, maybe.
Yes, it was interest balancing. So let's talk about what interest balancing really means.
Yeah,
and I think people are confused about that. That's a legal term, and I think that we need to really dig into that and let people understand what that means.
Before we get there, I'm going to take a total unnecessary detour, but I think it really puts the exclamation point on what you just said. You know this, not the followers. I was in Las Vegas at a real estate conference on behalf of the city of Pasco this past weekend. A gentleman came up to me and, got the classic, "Oh, hey, Washington." I look, he's got Longview, Washington, because it'll have your name, your title, and then where you're from, right?
Right.
And so Longview, Washington, and we start talking about the type of work he's doing, and somehow I slid in that we represented Wally's and Gators because he mentioned Kelso, which is, anyone that knows geography, it's very close, right? It's proximal to Longview. And this gentleman told me, he said, "You know what, man? I'm just excited to meet you, and I will tell you, there are plenty of places I could buy my stuff, but I go to Gators. I go see Wally because of what he represents, because of what he's done, because of the sacrifice that he's made to, be the face of this case." And I think that can never be lost. Regardless of what happens to this case, that his face, the Gators, needs to be etched into history as a true patriot of Wally Wentz, who's willing to stand up and say, "No, this is my right. This is my customer's right to purchase these and to use them as they please." Obviously, not in bad ways, but, you can go target shooting. You can go fire it off, right? There are so many lawful ways that these things can be used, and it's our rights to enjoy that. And it struck me that here we are, two guys from Washington, different parts of the state. We're bumping into each other, talking about real estate. I'm not even wearing my SMF gear. I'm there on behalf of the city of Pasco. And we turn to this case, and it just really highlighted the importance of not only our work, but of Wally's fortitude and his willingness to stand for what's right.
Right. Absolutely. I mean, it blows my mind, us sitting here doing the work that we do because we have a passion about it and we have that fire burning in us. But to really stick your neck out as Wally has that's another level.
It is. I mean, we've sacrificed, and we don't need to go over that. You and I have talked about that a lot. But, I don't know that I necessarily would have been in a position if they were like, hey, we think we're going to extract millions of dollars from you and just ruin you, especially, he's an older guy than us. I'm not going to say he's old because he's ageless.
My kids would say I'm old, so.
But, that's not the time when you want to mess around with risk of penalties. And
Not at all.
Wally has said this, as long as you're standing by me, I'm still standing, and that to me is like, this is the biggest compliment I can get. It's always nice to have a client that's willing to go, make hay with you. But, he really has not only supported us, but he trusts us. And that means the world to me, to you, to Austin, to the team, that we have like his trust.
Yeah.
When we have pretty much everything in our hands. And, I want to underscore this. Like, it's not a responsibility that we just take lightly and say, oh, crap, we lost a case or, stupid Supreme Court. We got the decision. I'm not going to lie. I was excited that we had two dissenters.
Right.
We have to call that for what it is. We had Justices Gordon MacLeod and Whitener, with Gordon MacLeod authoring the opinion, like, hey, dude, this is not constitutional. That's great. That's a start. And we talk about this often, and probably another podcast before I get too long-winded. We talk about how dissents become majorities. Mm-hmm. And especially since the way the majority wrote this and the way the dissent wrote theirs, I firmly believe that this case is tailor-made for the U.S. Supreme Court.
So in the dissent, and I haven't read it all the way through, did they mention the interest balancing issue?
I'll be honest, I'd have to look to see if they expressly called it that, but they analyzed it the same way, because interest balancing is where the state can't say X is more important than Y. In this case, public safety, preserving lives is more important than your alleged Second Amendment rights. So, it's how they like to tailor this.
Right. Alleged second.
Right.
And I want to drive that home because to your point about the dissent saying it's not constitutional, we're not crazy over here. And that's what that dissent means, is we're not crazy thinking that we're reading this, thinking it says one thing and it says something different, or there's some hidden meaning to it. The Second Amendment is very, very clear. And Article 1, Section 24 of the state constitution, very, very clear. And the intent when they were written was very, very clear. It has only been in the last 20 years, maybe decade, that they have reinterpreted these to mean something different. And so when interest balancing is introduced, what's going on here?
That's again the state's weighted version of public safety over your rights. And the Supreme Court expressly rejected that. They did so in Heller and McDonald, and then they reiterated, don't forget, in Bruin, don't forget, in Heller and McDonald, we said this, no interest balancing. For anyone that's following along, obviously Bruin's a couple years old at this point, but if you haven't read it, there's what's called the syllabus, and that's like the Cliff Notes version. The Supreme Court, the U.S. Supreme Court, not our state Supreme Court, the U.S. Supreme Court, when it has especially lengthy opinions and dissents, it'll go through and it'll have a syllabus, which is usually, if the majority opinion on that one's almost 60 pages, then there's like another 50 pages of concurring and dissent. And the syllabus is probably 3 or 4 pages. And it basically says we held, and it gives like 1, 2, 3, 4 in a paragraph of each. And it talks about interest balancing. So if someone doesn't feel like reading a whole law review article in a U.S. Supreme Court opinion, take a look at the syllabus, and that'll give you the roadmap. And they very expressly, not only in the syllabus, but in the main body of the document of the main court opinion, reject interest balancing, and do so looking backwards, not forwards, saying, hey, we rejected this before. It also requires that these laws, be compliant or consistent with the tradition of the regulation of firearms, right? That they look to the text and the history. And under those circumstances, not only is interest balancing prohibited, so you can't say we're going to save lives with this rule, but you also have to look at whether it's congruent with text and history of the Second Amendment. And of course, we believe, and I believe not only do we, but the dissent, which we believe got it right in the Gators, Washington Supreme Court case, talks about how all of those flow. They're, interest balancing is prohibited. You can't just say this is going to save lives. You can't say that only 2.2 rounds are shot in self-defense. They outrightly reject the self-defense argument. And I think the beauty of the majority opinion is they rely heavily on those things.
Right.
They rely heavily on the state's expert for the definition of the term arms. Thus, LCM is not an arm. It's not an integral part.
Not an arm, but illegal.
Exactly.
Not an arm, but illegal. I just want to make that. I mean, this piece of equipment.
And it's not integral.
Is not integral, not an arm, but illegal. Very dangerous, not an arm.
Yeah.
And I'm not going to go hit you over the head with it.
Yeah.
Though actually, as it is right now, it probably would do some serious
Yeah, I'm sure
damage.
it would. I'm not going to offer my school up. Yeah. And so, when we look at this case, again, we look at what the majority opinion has. And quite frankly, I think the dissent almost writes our brief for us to the U.S. Supreme Court. Because they take such a deep dive into what was said in the majority opinion. There are a couple things that I just wanted to share from the majority opinion about why I think, assuming the other two cases from the courts of appeal aren't taken before ours, meaning U.S. Supreme Court grants review of those cases, if they keep kicking those things down the road in conference, there are a couple of things specific to the majority opinion out of the Washington State Supreme Court. And I'm going to read them and we can talk about them a little bit. Although this is page 5 of the opinion for those who are really enjoying this and reading it along. Although we interpret the state right separately and independently of its federal counterpart, we have interpreted the meaning of the word arms using the Second Amendment precedent. So, they analyze whether or not that constitutes an arm, and they talk about utilizing Second Amendment. So now this really tees this up, not as a Washington state constitutional analysis, but rather as a U.S. constitutional analysis. Mm-hmm. And I think that is one of the hooks that gets us to the U.S. Supreme Court. Because, again, the notion here is the Washington State Supreme Court is our final stop of destination in the state, and no one can go outside of them except the guys back east and gals back east. And I think that when they start to analyze laws under a federal scenario, now it perks the ears up of the Supreme Court justices. And they just make this definitive statement. Thus, our interpretation of the scope of the two protections, that is the meaning of arms under Article 1, Section 24, and the Second Amendment is not inconsistent. Again, they're really hammering this notion that arms, they're analyzing whether or not that constitutes an arm under the Second Amendment. And again, I think that's one of the big hooks where SCOTUS is going to look at this and say, okay, you used our definitions. I mean, you didn't, but you used allegedly our definitions.
You tried to.
You thought about it. You referenced them. Thanks for the footnote. And then... So there's that element of it. And like I mentioned, they talk about their the state's linguistic professor and all that crap. And I don't think that's going to appeal to the U.S. Supreme Court. Back to interest balancing, the state argues that LCMs have virtually no utility for self-defense because, quote, individuals almost never fire more than 10 rounds in self-defense, end quote. And they talk about the average number of 2.2. That's pages 6 and 7. And so that's bringing us back into interest balancing. And then they give a nice little roadmap, kind of a segue into a different part of the analysis. But they say, we conclude that LCMs are not protected by Article 1, Section 24, because LCMs are not instruments designed as weapons. LCMs are not traditionally commonly used for self-defense, and the right to purchase an LCM is not among the ancillary rights necessary to the realization of the core right to bear arms in self-defense. Now, that third part about the corollary rights is There was a case out of the Ninth Circuit, which is our federal appellate court here in Washington, called Teixeira. And it talks about how important it is to be able to actually buy magazines, buy ammunition, those sorts of things. Because, you know, what's a gun without a magazine? What's a gun with, I mean, you know, and somehow, you know, you know, the notion from the majority opinion is as long as you have a magazine, it's adequate. Whether it's 1 round, 2 rounds. I mean, I don't know how you'd insert a 1-round magazine, but it seems that they believe that's possible and that it would fire properly. And so that's what they're calling the ancillary rights. Ammunition, you know, that's an absolute ancillary right, right?
Right.
Because if you can't have a projectile, you don't have a gun.
It boggles my mind that we're having these kind of, you know, basically word salad arguments at this level, especially when it comes to anything that involves technology, because we've already seen gun manufacturers go around this issue. There are now guns that are manufactured that don't have a magazine or a detachable magazine. You just insert all the rounds straight into the gun. Now there's no magazine to ban. It's got 20 rounds in it. You're good to go. You know, it's a little more difficult to reload, you know, but I'm sure there'll be some accoutrement that will come along with it that'll make it easier to load and more efficient. But this is just the frustrating part about this, because what they're essentially doing is that they're forcing that technology to continue to innovate and change and grow. And the state, even when they were in front of the Supreme Court, mentioned this, that there's other technologies out there. They start talking about laser guns.
I was going to say laser beams, if I recall.
Laser beams. So that's the next, in their mind, that's the next evolution. It doesn't have to even go to laser beams. I mean, we've got air guns that are coming out that are quite impressive with what they're able to accomplish. What is it that we're really, fighting for? And what it comes down to is that we really do. The reason why the Constitution was written as basic and simple as it was is because the right to bear arms, any kind of arms, whatever arms, as they come available, as they are invented, is intrinsic to us as as citizens of the United States of America.
Yeah, and that's really the crux of the case. And I think that's why the whole, dissecting the arms the way the majority did it, I think it bodes in our favor. I think it turns into where the Supreme Court says, nah, I mean, one, I think they're going to say, nah, you got it wrong. But two, kind of, why did we even go this far? To your question, we didn't need to go this far. You could have figured this out without going here. And so that's one of the hooks. And then back to the point of self-defense being basically the only lawful purpose. It talks about lawful purposes, including self-defense. When that's what you get from U.S. Supreme Court cases. But the state really tried to pair it into the only lawful purpose to fire a firearm is in self-defense. And I think that's where interest balancing comes in. And that's what expressly was prohibited by the U.S. Supreme Court historically. And I think that's where the U.S. Supreme Court is going to look at this. And the nice thing is, again, it's, I think in its entirety, if you include the dissent, is like 53 pages. Yeah, it's 56 pages. Mm-hmm. So it's not like it's a real heavy lift as the Supreme Court, as we draw, we're going to refer back to this a lot in our document, our what's called petition for certiorari, a writ for review. As we funnel back what the state Supreme Court has said, it's going to be really easy for the U.S. Supreme Court to track it, right? I mean, it's like a 16-page majority opinion. I think all those things really lead us into a point where SCOTUS is going to want to look at this. Mm-hmm. Again, I think the only thing is we're like third in queue, but the other two have been bounced around for quite some time and delayed. And I do think that, if you really want to put an end to whether it's ill definitions of the word arms and just fundamental whittling away of the Second Amendment, or if you want to, for like the third or fourth or fifth time, say there is no interest balancing, like this case is that on a silver platter.
Mm-hmm.
And that's why I really, in my heart of hearts, believe that this is the case that they've been looking for, and it comes from a state Supreme Court that has to be an attractive piece. So I mean, in my opinion, yeah, we're already pressing the button. We are working on our writ, our petition.
So I wanted to bring up a couple things because we have the potential for the perfect storm. We really do. With the ATF being kind of embroiled in some internal struggle, whether they're going to exist or not, even in the future, is on the table. With the executive order from Donald Trump about the Second Amendment being there. With this case now, this could be the nail in the coffin for all those those people that are trying to take our gun rights away, that are fighting for us, that finally says and denotes and I'm not going to say we're never going to have our rights challenged again, but at least in our lifetime, we have a chance to put a mark on this argument that is going to be very, very, very hard to overturn or change without a constitutional amendment being put out there.
Yeah, and again, I think it flows back to the language in the majority opinion is so straightforward.
Mm-hmm.
I mean, I don't think this is like, it's not crazy legalese. I think most members of the public can read and understand what they said. I'm not suggesting they're right or that any of us would agree with them, but I think it's so clearly written, and I think that's a huge favor to us. It's a huge favor to our Second Amendment. And it's a huge favor to Wally and Gators.
Well, so clearly written wrong.
Yeah.
And it just, just reading what I have read, so clearly stated that they don't understand what it is they're ruling on, what it is that they're opining on.
Yeah. And that's why I think this is the perfect storm for the U.S. Supreme Court to look at the issue and put its final stamp of disapproval on it. And I mean, that's why, I started off like, yeah, it's going to cost us a lot of money. We've got to fundraise on it. We got to make sure that we're able to keep the lights on here at SMF. But this is our opportunity to finally put Washington to work for good.
Right.
I mean, like, we get these crappy decisions out of a lot of courts. We get really crappy legislation out of our legislature. And here, God willing, we go to U.S. Supreme Court and hammer both the legislature and the Supreme Court. And I mean, it's a double whammy. It's a double dunk. And again, from my perspective, and maybe I'm jaded because I've so invested in this, I think there are just so many elements of this case that tee it up for value add from the Supreme Court, not just, hey, we want to tell someone they're wrong, but like, no, the value add here is we're telling you and all other 50 state Supreme Courts, and we thought we were clear in 2022 with Bruin. Apparently we weren't. So let us be extra clear with Gators guns.
So they got a chance to let these legislators know you got to write constitutional laws. You can't just start writing these laws and hope that they stick and you got something right, and maybe the courts are going to back you up and defend you when it comes to it. But I mean, just their lack of regard for the Constitution in both the state and at the federal level has been just crazy here in Washington, and it's frustrating. But what I want to talk about is, okay, what are our steps here at SMF? What's the next step with Gators? Obviously, we've got to address the Supreme Court here. So what do we have to do? And then let's kind of talk about what resources it's going to take. What are our supporters funding here? What are they donating to, and how is that going to get us to the promised land?
Yeah, I mean, so again, the case is bifurcated. I don't know what level of energy we're going to have to put into the Consumer Protection Act. I mean, hopefully we can get a stay on that one quickly, because I don't think it's a good use of resources for the state, the judge, or for us to litigate that issue that I wholeheartedly believe that the Supreme Court's going to overturn this. Now, the state may disagree with that, but that's what the judge is the neutral arbiter for, right? And so my hope is we can kind of knock that stay out because, two things. One, we're not consuming those resources, but two, it also kind of allows Wally to focus on fighting for the constitutional question, which is what the judge said since day one. We got to determine that first. So I don't know why he would depart from that. So hopefully we can kind of get the stay knocked out really quickly, put all of our eggs in the basket of going to the U.S. Supreme Court. So from the date of decision, 90 days, you petition the U.S. Supreme Court, like I called it, this writ for certiorari is, the Latin term, petition for review. We will open, they will respond, and then we'll have a chance to reply on that. So there will be some briefing, 180 days out, it should be concluded. 6 months from May 8th. So right around Thanksgiving time, all the briefing. And then the U.S. Supreme Court would decide whether or not they would review it. Then they'd put it on docket, assuming they decided prior to closing shop, and I don't know that they'd do it this quickly, but if they found it attractive and wanted to, grant our request for review, and if they did so before Thanksgiving or at least before Christmas, because they do take breaks there, there's a possibility that they could calendar us for probably next fall, so fall of 26, which means there's also going to be an opening brief, a response brief, and a reply brief. We're also going to simultaneously, I'm sure, be working the phones to get amicus briefs. I don't know how much work we'll actually have to do to cull those, because I think a lot of the 2A groups, they see our case taken. I mean, again, how many times have we seen one of the 2A advocates talk about, the Rhode Island Tactical, or I can't remember the Maryland case. Snopes, yeah.
Well, and we had amicus briefs from, and at this one, FPC, NRA.
I think Second Amendment Foundation, Water Institute.
So they're all very aware of this case.
Yeah, in fact, hopefully Austin will get on email either today or tomorrow. I told him to circulate the opinion. Not that I think they haven't seen it already, but just to tell them thank you. We appreciate your work, and we are petitioning the U.S. Supreme Court. And some of those folks, they made their living. Clement Murphy's, it's a law firm, but they've done a lot of the litigation on behalf of all those groups. Obviously, we can't afford them.
Right.
They're not cheap. I mean, we could take our $200,000 and ask for probably 2 to 3, maybe even 4 times that if we're going to hire them. Mm-hmm. And quite frankly, I'm not confident that Wally would be comfortable hiring anyone. Now, if we can get folks to help, even if we hired help, they're not going to take the reins. I think that's the big thing for Wally, is he wants to make sure that we have a supporting cast that's helpful to us. And, Austin and I have talked about this. If we get someone who's argued before the Supreme Court 3-4 dozen times that knows the judges on a visual basis, that may be in our client's best interest. That may be in our right's best interest.
Right.
I'm not saying we would not show up and not be there at council table, but if there's opportunity to bring someone who is a familiar face that would be helpful to getting, the right thing said. Mm-hmm. I mean, obviously there's no secret handshake, but there's a secret handshake,
right.
And
so what you're saying is we're not pulling any stops here. This is
all out. I mean, we are against a state that's running whatever deficit it's going to run, and then it's going to increase taxes on us, and then it's going to spend whatever the hell it wants on this.
And then they just signed another bill. Governor Ferguson just signed another bill. This is the day Governor Ferguson signed the bill for the permit to purchase here in Washington.
Yeah.
You got to have to ask the state to have your right.
Yep. And if I recall, no, that one didn't have an emergency clause.
No, that one's, I think,
it's like 26.
26 or 27. They pushed it out. They wanted to take your right away, but they're going to push it out far enough that you forget about it until all of a sudden one day you won't have it anymore.
Well, and fortunately, there's some litigation on that issue in other states, but that's again another podcast for another day. So look, I mean, it's a ton of work. I mean, so there's all the brief writing, then there's all the conversation that's had in between the brief writing, and then there's what we call a moot court. It's it's a pretend court, and whether or not Austin argues or I argue or we have someone else who comes along and argues because again they're a familiar face to those justices, we'll figure that out down the road. I'm not worried about it, but it's going to be a time and resource suck. And I don't mean that in a negative way because we get, God willing, we get to be before the U.S. Supreme Court on a fundamental right. Like, that's cool. That's phenomenal.
Well, and from a donor's perspective or supporter's perspective, if you're donating from across the country, first of all, thank you. But if you're donating from here in Washington, you get to participate in this. You get to say, screw you, Ferguson, because he was the AG when this happened. Screw you, legislature, for passing this law in the first place and not asking we the people for permission to pass this law. And screw you for taking our constitutional rights. We're going to fight this. We're going to go to Supreme Court and we're going to fight for our right, and we're not going to stop. And today being the day it is, there's a lot of rumblings about just not following the law. Just saying, screw it, it's unconstitutional, we're not going to follow this, it's our duty to not do that. Well, I'm not going to tell you to do that, but I'm going to say this is your opportunity to say screw you in a legal way.
Yeah.
This is your opportunity to jump on the bus, come along with us. This is our road to SCOTUS. Let's go get our rights back.
And that's exactly why we're going to pursue that road. I mean, if I thought it was frivolous, if I thought an appeal wouldn't get us anywhere, we wouldn't have appealed it. But to me, it makes absolute sense to take this case to the U.S. Supreme Court. It does. I mean, one, you can fall back on the silly notion of we've gone this far, we might as well finish it. Like, no, that's not it. This is, we gave them being the state Supreme Court, the analysis they needed to uphold our rights. And they botched it.
Mm-hmm.
And to me, again, there's several factors that weigh into why SCOTUS wants this. And I do believe, like I said, I know other folks disagree. I do believe they've been waiting for this case, maybe not knowing that it's this case, but this out of a state Supreme Court. I mean, the analysis is so clear. I mean, it's, I don't want to oversimplify it because folks be like, well, then why do you have to work so hard? Right. Well, no, we got to get this right. We got to get it perfect.
We don't want to oversimplify. We want to sell this. Yeah. This is your chance. If you support your Second Amendment rights, if you support the fact that Wally stood up for all of us, he's the one leading the charge, is the tip of the spear. If you want to throw your support behind Wally and his willingness to take those darts for us, this is your time. This is your time to donate, to support. Tell your friends. Tell everybody that owns a gun and enjoys that right. Tell them about what we're doing and get behind it. Support us. Push us through. We've got a lot of work ahead of us. We cannot do it without you. I don't know how I can make that any more clear. We cannot do this without each of you who support the Second Amendment ponying up and putting your money where your mouth is and putting your actions where they should be and making sure that this fight gets taken all the way to SCOTUS and we finish it and we take it across the finish line. And I know that timeline way out next fall seems really far out to be waiting for our rights to be restored. But that's what we've got to do, and this is how we're going to do it and make sure that there's nobody that can challenge it, again, at least in our lifetime, that the Second Amendment stands. Article 1, Section 24 of the state constitution was damn clear. And that's what we have to do, and that's what we're asking you today. Tell me a little bit about the other cases that we've got going on that are running in tandem with this. We've got Guardian Arms, we've got Brumback. Where do those sit, and how does this case affect those?
Yeah, so Brumback was actually the first one we brought on the Large Capacity magazine. We filed it, I think it was like July 6th, right after the law went into effect. So 2023, I think, 22?
I think it was 22.
2022, yeah. And we filed that in federal court, Eastern District of Washington. Had some hearings. Had one right before Thanksgiving of that year, and the judge denied our temporary restraining order and our preliminary injunction. And midstream, we got caught in this crossfire of the Gators case, and so we put a stay on that case. Really, we believe that the Washington State Supreme Court is going to have a decision, and it's going to help the analysis. At this point, I think we're looking at staying it still a little bit longer until we know what SCOTUS is going to do with Gators case. To me, it doesn't make sense to litigate the same issue in two different areas when we believe the top dog is going to rule on this. And so we've kicked over a status report, just a document telling the court where everything is and where we think the Brumback case should move, and why we think a delay for a little bit longer might merit some value. And that's my belief. I do believe that the U.S. Supreme Court will take this case, Gators, and there's no sense in litigating the same issue elsewhere.
Right.
If they reject that, we're going to get into discovery on that issue. The case that I'm excited for of how this Gators decision impacts is Guardian Arms. That's our so-called assault weapons ban, which bans, certain types of firearms, certain components of firearms that would be used to either repair or to modify yours. Because of the way arms was introduced in this opinion, and it talks about, it really parses out and tries to split the hair, but basically says the magazine's not an arm because it doesn't really project things.
Not an arm, but illegal.
Yep.
I just think it's hilarious.
It is. Yeah, I can't buy or sell it. Good thing you have it.
Extremely dangerous. Not an arm.
Yeah. But because of the way the Supreme Court analyzed the term arm in Gator's case, I do actually think it bodes well for the Guardian Arms case. And that case is in Thurston County right now. We sought a temporary restraining order we started that case in Grant County, got bumped to Thurston County, sought the temporary restraining order and the preliminary injunction. Both were denied. I don't think we've gone to the permanent injunction. The next step would be to do cross motions for summary judgment. We've had depositions in that case. We've had expert witness testimony and expert depositions in that case. So I do think, of course, there's the whole interest balancing in this case where it talks about, in self-defense. But that law, the assault weapon ban, listed I can't remember, 72 guns or something like that. It expressly prohibited certain types of guns.
So you talked about being deposed. I was deposed actually in that case, and the opposing attorney actually asked me about every specific model of gun that was banned in that piece, and it's insane. If anybody knows anything about guns, there's literally thousands of different models and configurations for guns. It'd be like asking if you could name every car out in the parking lot and tell me all the different, features or engine that's in each one. It was just funny because clearly he didn't know any of those things, but he wanted to ask me, if those guns were used in self-defense in each and every single one of them.
Well, and that's their tee-up, is that these are non-self-defense firearms. That they don't bode well for that type of thing. And then all the parts and pieces, that somehow those wouldn't be meaningful to either the operation of the firearm or that they couldn't be used in self-defense. So I think the way that the Gators case was analyzed, to me, it's a positive thing for Guardian Arms. We did put a stay on that case pending the outcome of Gators, and now we've had it for 12 days. So I could see a world in which we file our cross motions for summary judgment, and anyone that's followed us along knows that that's what I call a tap-out motion. It's a motion that basically distills the trial into pleading. In other words, papers. And the way that you win a motion for summary judgment is you show that there's no legal issue and that there aren't any issues on fact. And so it's that there's no genuine issues to a material fact. It's what the standard is called. So really no dispute of these facts. And so I think we can win on it on motion for summary judgment, because I do believe that the Gators analysis really opens the door to these are all arms.
Right.
You can't prohibit them under Gators. And if you want to prohibit them, you can strike through, Your Honor, all the ones that you deem arms, and you figure out which ones aren't.
Right.
And I can't believe that there will be a judge that's going to sit there and literally oh no, that one's not an arm. That one's, that one's prohibited.
The circuitous logic here just drives me insane.
Well, it does. But while I don't enjoy it either, I do think that that's what helps us with guardian arms.
I think so too.
And so, hopefully we'll get that fired up either this summer or fall. We've got a lot of other things on our docket that are non-firearms that have taken a lot of bandwidth, a lot of brain space. And obviously we've pled hard for money. We're going to plead harder for money.
Yeah, we're going to need it for all these cases to continue to go forward. So we're going to set up campaigns for these. If you're following along and you want to support, we'll have a Second Amendment, just overarching umbrella fund you can fund. We'll have funds for individual cases if you deem that one of them is more important to you than the other. But what it comes down to is that these cases are resource intensive, and they will need as much attention and as much monetary funding as we can muster. And to Pete's point, so we can keep the doors open. I mean, literally, these cases have sucked our funds down to the point where we don't know where we're going to be in 6 months unless we can get these funded. Because to his point, we are going to pursue this. And if we pursue this and pursue it to the point where we can't do it anymore, that's the way the cookie crumbles. But with your support, with your help, that means we can get this over the finish line. We can go to the SCOTUS and we can win your rights back.
Yeah, I mean, I absolutely think that's the perfect ending of this. Is we're not just fighting for this because we like guns. I mean, we do. But it's not about the firearm. It's about your right. It's about the ability to protect what's inherently protected under constitutional provisions. And we've departed so far from what the founders wanted, not because of technology, not because of semantics or linguistic changes, but because people have bastardized the law and they've mutilated the Constitution, just like they tried to our kids. And
another battle we're fighting.
Yeah, right. And we can't let that happen. I mean, I'm not willing to let that happen on my watch, and that's why we're here. Because, whether it's protecting our kids or protecting our right to protect our kids or ourselves or anyone, or just go enjoy shooting at a piece of paper.
I like shooting at bombs, but...
Well, yeah. I don't have those in my backyard.
No, but you'll have to come up with it next year. Maybe
I guess I don't have a target in my backyard.
We'll make sure we don't schedule something on the same weekend again like we did this year.
But the point is, we are here to fight for that, and we will keep fighting. As long as we have the resources to do it, we'll do it. And that's why we're here. That's why we're telling everyone what we're doing. We're asking each one of you to tell 10 friends, 20 friends, 30 friends. Tell them that they got to check us out, that there's a real shot at changing the United States out of Washington in a positive way. I mean, how many times are you going to say that?
That'd be amazing. That would truly be amazing.
I mean, the other guys say that we're going to save democracy through Washington.
Well, then they think they're in some sort of constitutional crisis. I'm not quite sure what constitution it is that they're in a crisis, though, but it's not the one that we all read.
Not the United States Constitution or Washington State.
It's some alternative lifestyle constitution, I guess. Anyway, hey, thank you for for tuning in. We'll try and keep you updated as much as possible. Today was 2A Tuesday. That's why we gave you an update on all of our 2A. We are accepting funds and donations. We need them. You need them because it's your right we're fighting for. And thanks again, and we'll talk to you soon.